All right, everyone. We're going to get started with the panel portion. And I'm going to start by introducing one of the panelists. Okay, great. So, right here excuse me, to my right is Anam Ella Durrani. She's the founder of AED Designs, a successful made-to-order clothing line she established at the age of 16 while living in Karachi, Pakistan. She worked 14 to 18 hours a day to launch and build the company and its brand, and helped to catalyze an influx of new Pakistani female designers as her company achieved recognition and acclaim. She identifies becoming an entrepreneur as a teenage girl, in defiance of social taboos and constraints limiting and stigmatizing female independence as her proudest accomplishment. Anam completed her bachelor's degree in 2017, graduating summa cum laude from UCLA with a major in gender studies and minors in disability studies and labor and workplace studies. While at UCLA, she became an intern with Repair, and she has remained active in the Repair community since graduating, now serving on the board. She's now the CEO of Durrani Investment Corporation, and in that capacity is working in real estate development in Los Angeles. She also continues to run AED Designs from LA. In addition to her professional obligations, her work with Repair, and her communal activities as a Muslim woman in LA, she engages in humanitarian work in her home countries of Pakistan and Afghanistan, and is presently building a school for street children in Karachi. Lastly, as a fun fact, in addition to her Pakistani ancestry, she is also a direct descendant of the last king of Afghanistan. And though Afghanistan has not had a monarchy since 1964, she is still recognized culturally as Princess of the Blood.
Start us off.
Hi. So I'm going to introduce Ann as our first panelist. Ann's passion for resolving barriers to health and access to person-centered care led her to volunteer on several nonprofit boards to develop policy and programs to better serve persons from disadvantaged communities, including persons with disabilities, their families, and caregivers. Over the past 20 years, Ann's diverse professional experiences included serving as a long-term leadership educational in neurodevelopmental and related disabilities, LEND, fellow at the UC Davis Mind Institute, Santa Clara County Public Health Policy Aide for County Board Supervisor Ken Yeager, Diabetes Prevention Project Coordinator for the Indian Health Center of Santa Clara Valley, Personal Health Assistant and Lifestyle Health Coach for Consumer Health Startup with Mayo Clinic and Social Plus Capital Partnership, Community Engagement Coordinator at the Health Trust, Community Organizer at Close to Home Domestic Violence, Manager of Cambridge Innovation Center, Civil Advocate for the Asian Task Force Against Domestic Violence, and Director of Programs and Development for VA. Wow. Currently, Ann is a Program Director at the California Foundation for the Independent Living Centers. Prior to joining this, in January 2019, Ann worked as a statewide assistive technology project coordinator and grants administrator at the California Department of Rehabilitation. Ann also is excited to serve as a board member for Disability Voices United. Disability Voices United is a statewide organization directed by and for individuals with developmental disabilities of all ages and their families. Together, DVU advocates for choice and control over our lives, meaningful outcomes that matter to us, and systems that are equitable and accountable to us. Ann holds a Bachelor of Arts in Psychology from University of Illinois Chicago and Master of Science in Healthcare Administration and Change Management from California State University East Bay. Ann enjoys discovering new local cafes, hiking trails, spending time with her partner and rescue kittens, and supporting as well as advocating for Martin, her brother with autism and traumatic brain injury. Welcome, Ann.
Thank you. So good afternoon, everyone. It's such a privilege to be here to share my story and my family's journey with you all. And thank you for providing me this opportunity to be here. And thank you for Repair and everyone here in this room to be here. For disclosure purposes, I received permission from my family and Martin to share our experiences and photos with you for the purpose of learning and building solutions to resolve the barriers and issues of conservatorships that we're facing in California. And prior to me sharing my story, I would like to ask everyone for a moment of silence to honor all the families that had experienced the trauma and the issues that we heard today in the documentary, and that we're still struggling. So I asked for a moment of silence for the ones that we lost and the ones that we're still trying to break free from the barriers. Thank you. So if everyone can just take a deep breath and then join me into the story that I'm going to share with you today. So to provide you some context and background, my family arrived in the US in 1975 as Vietnamese refugees. We are fortunate to have been sponsored by a Catholic church in a very small town in Illinois. My parents risked their lives for their children to have a better future, as my father would have been executed for his military ranking and support of the American soldiers during the Vietnam War. Sorry. It's not advancing. So I just want to share our journey between our conservatorship and guardianship across the states. So we ask, why California? So as my bio has shared that my brother suffered a traumatic brain injury during his delivery. He also has autism, and he's on the spectrum, and he has very severe issues with sensory processing disorders. And it's due to a medical malpractice suit that we were awarded in 1988 of a fund of a trust and a state to care for him for the rest of his life because of the expansive disabilities that he suffered from the injury. And in Illinois, we were a small minority family. We were not really welcome there. And especially when my brother, who has very severe sensory processing disorders, was not welcome either in the school system that was not very tailored to his needs. And this is where my family had become his advocate to make sure that he has his rights to live a very independent and meaningful life since his birth. And so why did we choose California? Well, nice mild weather compared to Illinois, and near family and Vietnamese cultures and communities, the Latterman Developmental Disability Services Act, the 21 regional centers across California, independent living, supported decision-making and self-determination, progressive policies, protection of rights, and safety net services compared to Illinois and Florida, where my family had eventually went to Florida for warmer climate and weather to support my brother with his sensory processing disorders. And as we journeyed, I just want to point out very interesting areas that you can see that was highlighted with the documentary film that you've seen earlier, and how it played out and how we ended up here in California. So about 2011 is when the family plans to transition from Florida to California for better services and support for Martin, because my mom was named as his main guardian and caregiver since the day he was born. And when he became an adult at age 18, my mom was still awarded the guardianship in Illinois. And as we transferred to Florida, we were also awarded as his main guardian. And we had a co-guardian of the estate, which is a named financial institution. From here, we arrived in California in 2013 because we're planning to transition, because at that time, my mom is age 79. So she was fearful that if she were to be incapacitated, that the state of Florida will take my brother away and put him in institution, because the laws of the state did not support another co-conservator or a family member to be in there. So we'd have to fight the courts in Florida to gain access to my brother. So this is the planning succession that my mom was thinking ahead because she always loved and cared for her children. And as when we arrived in California, we were awarded the temporary conservatorship, both my mother and I, as co-conservators of the person and the estate, plus also another co-conservator of the estate, meaning a financial institution as well, to handle the estate. So here's just a little glimpse of my family from the mid-1970s to the 1990s, to just give you more context of how close we are and built we are as a family. So I'm number 10 of 11 children. Martin is number 11. We grew up together. We shared many, many memories together as well. And so when we arrived here in California, after our temporary conservatorship letters were up for renewal to become permanent letters, we were challenged by the court PVP counsel, which was appointed to oversee my brother's case. She suggested to the court that a professional fiduciary should be in place because there was a miscommunication between the Florida courts and the California courts of how to handle the estate matters, how to sell the home, and how to transfer the guardianship to conservatorship in California. And so we were forced to sign a stipulated order to give power to a complete stranger. And this professional fiduciary was told that she was supposed to provide critical services to seniors and persons with disabilities and children, including daily care, housing, medical needs, and financial management services, range from basic bill paying, estate, and investment management. This is after 34 years of Martin living with my family and under the estate of and care of my mom. We did not feel right at all to hand over the estate and the conservatorship letters to a stranger. And so we asked to make sure that there is a stipulated order and that there's an attachment included in the instructions if we were to sign over the conservatorship letters. And it was supposed to be temporary, up to a year. And we were interviewed by both the PVP counsel, and we also were able the opportunity to interview the the conservator. And she said that this is very unusual, that they don't step in until there's a conflict in the family, or if there's another opportunity there, but she shouldn't have been appointed, as that came from her own mouth. And just to buy us reassurance that, oh, don't worry, you can sign the papers over, and you'll get your brother back as soon as the funds are transferred and the house is sold in Florida and transferred to California. But still, something felt really, really wrong. And the attorneys at that time said that you have two choices. Either sign the stipulated order and wait, or you have to go to trial and lose all the estate that's available for your brother. So we were not allowed to have any interpreter for my mother, who is not an English speaker. And I'm there to interpret. But I'm not a legal specialist. I don't know the ins and outs of the law. All I know is I need to protect my brother and protect my mother. So all I have to ask is for those attachments to make sure that in that order states that my mother is to be consulted for any caregiving, any hiring of the caregivers, any day-to-day management needs to go past my brother, mom, and my older brothers and siblings. The family needs to be involved. They agreed to just only allow my mother and myself because we were assigned as a temporary conservator, but I couldn't add anyone else in my family. And I pointed out also, I thought there was a probate code law in California to protect that if there's no family members available, then a professional conservator can be appointed. So why is this happening? Why is my brother being appointed to someone who doesn't understand disabilities and not how to care for my brother? And they said that this is just up to the judges. So you have to sign the orders. So after the signing of the orders, everything seemed okay for about the first 3 months. And that was in 2014. Then when 2015 rolls around, we've been asking for supports for my brother. His dental preventative care was denied multiple times. It led to bleeding gums and losing of his teeth. We've been trying to advocate and ask from the PVP Council and the court-appointed professional conservator. She denied everything and would not allow my brother to see and seek dental care. We also reached out to the Professional Fiduciaries Bureau to file a complaint because she's not following the court orders. And we couldn't wait for the next court hearing to ask permission to enforce that my brother needs the care that he has to have. But then we didn't know that what happened was that she purposely left a full year of neglect, caused my brother to be triggered so she can isolate and have evidence that the family is not suitable for my brother's care, that we are endangering him, that he's not safe to be in the same home with my mother. So it led to emergency surgery, oral surgery, and heavy anesthesia that caused him on the third episode of the dental care to have an aspirated during the procedure. That led to emergency room visit in 2015. And that led to a hospitalization of 21 days, restrained to a bed, and not released back to the family home. After the 21st day, the family came to visit. My brother was not in the hospital. We were frantic. We couldn't find my brother. We didn't know where he was removed to. It took another ex parte hearing of my mom to beg and plead the court to allow us to find where my brother was placed. We didn't know where he was. He didn't know where we were. And when we finally were able to seek visitations, it took another 2 months in order to actually have contact. And during those 2 months of isolation, they released photographs of my brother. And let me remind you again, my brother has a sensory processing disorder. There's times that he cannot tolerate clothing. It triggers him. So we always provide a safe space in his home for him to digress. And usually he likes to remove his clothing and just wrap himself in a sheet because the tags and the buttons and the zippers just drive him nuts. And so what we saw was just horrifying. We saw a photo of duct-taped clothing, weighted boxing gloves on him, so he cannot remove the clothing. And he couldn't ask for help because they would just put more sedation and more drugs. And we couldn't reach him. We couldn't comfort him. We couldn't be there by his side because we had to wait for a court order to come and visit. And when we finally did, we were restricted on what the visitations were. We couldn't touch him. We couldn't feed him. We couldn't give him any type of contacts, and we were watched. It's no different than going in to visit someone in an institution or in jail. But why? What did we do that was so wrong? We didn't understand. We called the Adult Protection Services. We reached out to regional centers. We reached out to the Disability Rights of California. I reached out to anyone that I can to figure something out. But I keep getting circles and running around in circles because they kept saying that you already have a case open. There's nothing that we can do. This is a civil matter. You have to go to the courts. And so this is where I sharing the family struggle in California because we know that we're not alone. I thought I was a unique case, but during my struggle when I reached out to the families, because I noticed there was a list in the probate court of all these hearings of conservatorships. And I was very fortunate to reach out and connect with Linda Kincaid, Linda Deemer, Terry Williams, and I kept asking for more stories, asking for more support because I just couldn't believe what my family has gone through because we were built to trust systems to protect our rights. We were educated in a system that our rights would be respected, but we didn't know that it would just be swept under the rug and that would just be another case number, and that our voices are silenced. We're not allowed to speak before the judge. My mother is not allowed to have a translator. Even my brother, who is nonverbal, can't even have a specialist, a speech and a gesturologist, meet with him and have access so that he can go through any type of care plan meetings or any type of things that are made on a day-to-day decision for his care. So these are the photos that you see that when we visit with Martin, my late mother passed away 2 years ago. And on the day of her burial, I had to, again, go seek an ex parte hearing to ask the court to enforce an opportunity for my brother to grieve with his family and spend the weekend to pay respects to my mother that cared for him for over 34 years of his life. And they had the audacity to ask me, can I wait another week to bury my mother and extend the funeral services because the conservator was on vacation and couldn't come back in time to be in court. And I said no. And so this is where I ask everyone here to understand the issues and barriers in California and LA probate court. So from 2014 to 2019, we had to cycle through 7 probate judges on the case. PVP counsel denied language and cultural interpreter for conservatee. PVP counsel and professional conservator denied medical specialists and services in autism for my brother. PVP counsel and professional fiduciary conservator denied family visitation and involvement with my brother, and limited list of attorneys qualified and willing to represent the family are some of the issues that we have seen. We also see forced medication, isolation from family. Martin had suffered and lost over, the list goes on, and I'm not going to go into those details because I want to be mindful of the panelists here. And so I just want to dive into how and why is this happening. So these photos here, you can see there is Martin with the duct tape socks and the weighted boxing gloves, the serious injuries that he's receiving that we keep reporting and nothing happens. And this is where we have the broken system and the loopholes. There's lack of training for judges and PVP counsel on the sensitivities and knowing how the family and how to engage the family, to protect the family, and to understand their rights to have access to care and supports. The lack of oversight for professional fiduciaries, the adult protection services lack enforcement and authority, the professional fiduciary lack authority and enforcement due to funding issues to make sure that the licensors are checked and that the filing and everything is checked. Police officers, first responders need the support and understanding where their authorities lies when they come and investigate these cases, especially when someone is nonverbal and not able to speak for themselves. The disability rights of California rarely take individual cases. They're especially litigation cases they cannot take. Poor to non-existent checks and balances of the court conduct, PVP counsel conduct, and professional conservators' conduct is gone unchecked. Poor coordination of services, especially of persons with disabilities. And here you can learn more about the conservator issues and abuse across California through the website here that I'm sharing from Linda Kincaid from CEDAR. You can see from Alameda County all the way down to Santa Barbara County, there's lots more cases happening. And the next steps that I would suggest as a family and a person that's trying to survive through this is we need to update legislative policies and oversight. We need to end isolation and abuse. We need to have support person-centered care plans. We need to respect self-determination and supported decision-making. We need to end siloed systems and create more collaborative efforts for all. Thank you.
That's fantastic. So powerful. Thank you. No questions yet.
No questions?
We'll have Q&A at the end. So for Brooke. Thank you so much. I'd like to introduce Burke Weitzman now.
In early 2017, Brooke Weitzman and William Wise founded the Elder Law and Disability Rights Center to address the justice gap in Orange County. Turn towards you. The Elder ELDR?
It's an abbreviation for Elder Law Disability Rights.
Okay. The ELDR Center provides free and low-cost legal services. The mission, Aging with Dignity. As a part of that mission, Brooke set out to address the housing crisis in Orange County. Before they had an office, she was in the Santa Ana riverbed asking the unsheltered community what they needed. By the end of their first year in operating, and with the support of co-counsel Carol Sobel and Catherine Sweetser, Brooke successfully litigated 2 federal cases to stop the destruction of property of homeless individuals. As the spotlight turned to the housing crisis, Brooke and her co-counsel filed 2 more cases in the federal court. This litigation changed the landscape of housing and homelessness in Orange County. Without the option to criminalize unavoidable behavior or blame the victims, Orange County and the cities turned to evidence-based solutions. They began working with developers and with each other on housing options. They began bringing in emergency shelter operators to reduce street deaths immediately. And they began taking a healthcare first approach rather than an enforcement approach to addressing the local housing crisis. Committed to ensure our community can age with dignity, Brooke continues to work through the legal system to support low-income communities, advocates, developers, and governments in finding and implementing solutions while protecting her clients' right to due process, disability accommodations, trauma-informed care, and justice. Welcome, Brooke.
Thanks. So we are we're just kind of 3 years old, so we're a very small new organization. We have not so far done a lot of work on this issue, but we have done some, and it's certainly a disability rights issue and something that we've been looking into. So it seems like more of the people in the room are people whose families are impacted by the conservatorship system, and probably it doesn't seem like there's a lot of law students or lawyers here, so you all may already know the process better than I can explain it, but I'm going to give a quick overview anyway for anyone who's here who isn't already familiar with it. So basically, right, in a conservatorship process, the goal, and there's certainly times when it's appropriate, right, of the court is under the probate code to determine the least restrictive means of ensuring that someone's needs can be met. The problems come when that goes wrong, right? When the courts don't actually determine least restrictive. But the process itself is long and complicated and expensive and inconsistent. And so like you heard some of before, and like many of you have seen, it's different in every county and in every state. And that means that even lawyers who are practicing in this area, if they cross from one county to the next, may have to learn a different procedure or a different system, or who kind of the players are, or how that particular judge handles it. And it seems to be more different in this particular area of law than in a lot of other areas of law. Right? So one of the other things that's a little bit unique about the conservatorship process is almost like, which I realize is kind of a strange comparison, but almost like gang injunctions. It's a civil area of law with seemingly criminal consequences, right? Where a civil judge makes a decision like taking away a person's rights, but the results cross over into sometimes criminal for the family, sometimes support criminal behaviors of parties involved, but importantly result in someone being in circumstances that can be sometimes jail-like or worse, except without the benefits of the protections you get when you're in jail, because then the government's responsible for things like your health care. And so there's this kind of complicated balance of trying to ensure that people have the support they need in the least restrictive situation possible, but in a system that really isn't built out because there hasn't been the level of oversight and consistency and policy making to ensure that it's stable. So it starts off with extensive paperwork, which people inevitably end up paying lawyers tens of thousands of dollars to do. People who try to do it on their own usually end up with a judge sending them back 15 or 20 times, telling them something's missing, or a box wasn't checked, or a signature didn't have a date on it. And in the course of doing all of these dozens of forms, it is surely easy to miss a box or a check mark. Lawyers do it all the time. Certainly people who don't fill out paperwork for a living are going to also do it. But when you're talking about the life of one of your family members and their access to their family, to their medical services, that box could be the difference between you getting your hearing now or you getting continued to another hearing. In Orange County, you're often waiting for 6 months for your next hearing. Right? And so the process itself is this tedious and extra slow process where you can't get in front of a judge immediately. And then you get into these issues of notice, right, that you heard of some. So in a criminal proceeding, you would get notice of your hearing, you'd get a ticket, or you'd get arrested and you'd get a court date. And if you missed the court date, what would happen is the judge would issue a warrant for your arrest for missing the court date. They wouldn't find you guilty of the crime. They wouldn't have the trial without you. They would issue the warrant, and eventually you'd get arrested and brought to court, and then you'd get to have your trial. But in this civil context where things are treated differently, if you don't show up to your court date, and the court may think you had notice, right? And when the court's issuing warrants in the criminal context, they're doing it because they think the person had notice, and sometimes they did, and sometimes they didn't. But in the civil context, whether the court thinks you had notice or whether the other side is saying we weren't able to give notice, we've deemed it okay to continue with the process without you instead of doing something. And surely I'm not suggesting we should start arresting the people who don't know about their hearing and taking them to jail, right? But kind of thinking through that process of why have we made it okay to continue the hearing without the person when we have this kind of known pervasive issue of notice. What alternative process could there be that would ensure that there is notice and that the person does have an opportunity to be there and does have a translator the same way every other person has a right to a translator in other types of court proceedings. And so the way that this process is set up now in that temporary hearing, which many of you probably know, that there's often not a hearing at all. It's often just the paperwork, and the people are never in front of the judge. So even if there was notice, if the person didn't get a lawyer or couldn't get to court, the judge may never know that because the system isn't designed to actually ensure that there is a hearing at each step of the way before any decisions are made. So once you get past all of the procedural problems, you get through all the paperwork, and you get into kind of this system we have of private professional fiduciaries. We, at least in California, right around 2007, started licensing private professional fiduciaries. That certainly helped with some things. It clearly did not solve all of the things. But that licensing process at least means now we know who are the people that are acting in this role, both kind of the public guardian employees and the private professionals. There's some accountability for them to do some reporting. But we're still seeing, because this is a 12-year-old process, and because it is something that the general public is not focused on until it impacted your life, probably weren't thinking, how am I going to fix the conservatorship system, right? And so until it's something that's kind of a more mainstream consideration, there is limited oversight of that process. So we have lots of great fiduciaries who step into cases where there is no family and there is no one to make the decisions. And then, like in many professions, we have some terrible fiduciaries who do criminal things, and the oversight system is not catching them and is not protecting the families. And we don't have a good way in the current system to ensure that in every case that the families are turned to first, to be thinking about the right of the person to have access to their family, right? When we look at kind of children's law, there's a lot of focus on the right of children, the right of parents to parent their children, the right of children to have access to their family, whether that's siblings or parents or more distant family. When judges in family court are looking at the rights of children, that's a consideration. And we don't see that to the same extent when judges in probate courts are looking at conservatorships. There's not the same weight given, and that's partly because there seems to be a fear of this rampant elder abuse, and people make assumptions that families are doing things wrong, but partly because we just don't have an effective system of oversight to ensure that there's notice at every step of the way, ensure that there's consideration. And in large part, right, one of the biggest issues that we see, and something that I think drives a lot of the change in processes for lots of areas of law, but especially here, is really taking a healthcare first approach. That's something that historically we haven't done, right? As a country, we never really thought of healthcare first. We did law enforcement first, we took away people's rights first, but we didn't start off with people's healthcare needs. And so figuring out how are we going to catch up on making this a healthcare first area of law, where it is a healthcare professional, where maybe the court does have, its own healthcare professionals, or always ensures that the healthcare professional who's writing a letter has a relationship with that person, not just a relationship with the fiduciary or the attorney, but really looking at how we can take that healthcare approach, and importantly, how that healthcare approach can empower people to make their own decisions, even if they don't have capacity to make all their own decisions, right? And so you've heard probably through your own experience and throughout, I think, the movie and the speakers today, terms that reference the idea that instead of our current process, which is really set up to take away a person's right of decision making, right, to decide that a person's not capable of making their own decisions and give that right to someone else, that there first be a step of, is there a support system that could allow them to make decisions, right? Is there space to figure out what they need and to support people, even if they have reduced capacity in making decisions? And I think we see a really stark difference in how that's treated in families that have money and families that have no money, right? And so that's where we get into this issue of abuses by fiduciaries. So a lot of the work that I do is within the homeless context, right? So I represent all the homeless folks in the Santa Ana riverbed throughout Orange County in lawsuits against governments to get shelters and housing opened. And I can't tell you how often I get calls from shelters. We have someone in the shelter, the hospital dropped them off. They clearly have no capacity. They can't make any decisions. We can't take care of them. We've called APS. We've called the public guardian. We've called everyone we can think of, and they just can't get someone to show up and help them get this person conserved. And so you have to wonder, right? Why is it that we can't get a conservator for the people whose only income is SSI, supplemental security income, right, who only get disability, or who have no income at all because they didn't even have someone to get them on disability, who aren't capable of paying for a place to live or finding a place to live, and who aren't capable of making their own decisions? Because we do have a growing number of seniors who are homeless, right? Senior women are currently our fastest growing homeless population. And so what are the systemic causes and funding, and it's, right, and we look back at it's government, the kind of top-down decisions about priorities, about what information we have about funding that drive this system where getting the public guardian or the private fiduciaries is easy even when nobody wants them in cases where there's assets, but impossible even when the person desperately needs them in cases where there's no assets at all. And how do we bridge that gap, right? How do we create, cross the system we have into something that will serve the people who don't have anyone, that will support the families of people who maybe do need a little extra support but have family, and will not interfere with the families that are able to take care of their loved ones. So I kind of figured I would focus on a couple areas of where we can start to make those changes, where the court might be able to improve. And again, knowing that you all who are in this every day probably have a lot more thoughts on this than I do. But first of all, we've talked about a lot today, right? Figuring out what does that oversight look like? What is the role of the Fiduciary Oversight Board? What can we do to increase transparency in the complaint process, right? To ensure that every complaint is investigated thoroughly, that it's investigated not in a vacuum, right? That when someone calls and says, this fiduciary seems to have billed 32 hours in one day, but it happens to be on 4 different cases, that they're not going to investigate one case and say, oh, well, all the billing on this case seems perfectly reasonable. That instead they're going to look at the big picture and look at that individual as a whole and look at all the cases they're billing. That when someone calls and says, hey, this fiduciary seems to be billing at their fiduciary rate for everything, including making photocopies, maybe they forgot that administration might be worth less money than their regular professional activities. And that they'll look at not just, just that one case, but look at, does this person have other complaints? And right now, we have no idea if they're doing it. The response seems to indicate they're not doing that, but the process isn't transparent enough for us to really know what what does and doesn't get investigated when complaints are filed. So figuring out kind of how do we improve that oversight and how do we ensure that it really is only being granted when it's the least restrictive alternative, right? That we're really, in every case, looking at the healthcare needs, looking at the family available, looking at the capacity of the family available, and figuring out, is there any less restrictive alternative, which we all know is in the code section, but lots of things are laws that aren't always entirely followed, right? We see that in every area of injustice. And so how do we get that to be followed here? So the last thing that I will touch on, because my time is mostly up, is looking at kind of the ethics rules of professional fiduciaries, right? So we as attorneys have a comprehensive set of ethics rules. They're very specific, including like when we can and cannot date our clients, and who we can and cannot take money from, under what circumstances, who can have ownership in law firms. And so we spend a lot of time learning and following these ethics rules. And when you screw them up, especially when you screw them up involving someone's money, it's easy to lose your license. And so figuring out how do we, and there are ethics rules under the fiduciary's oversight, but how do we get those ethics rules to be as comprehensive as they need to be for people who have so much control over someone's life? Is there some obligation that they do have some form of medical training if they're going to be making medical decisions, or some minimum amount of medical training people they consult with need to have, right? Because we are talking about complicated medical decisions, and the people often do have the ability to have some input. And so the ethics rules right now exist, but they're not particularly comprehensive. And so another area I think we need to look at is how do we bring that into, how do we get those ethics rules up to an acceptable standard, and how do we put that in front of the court sometimes, right? So when we have these cases, right now what we say to the court is the person failed to do their accounting, or they didn't follow through with an order. But we're not saying to the court, this fiduciary needs to be removed because they breached their fiduciary duties, and here's the fiduciary duty that the ethics rule that they were obligated to follow that they breached. And is there space that we can start bringing those issues in front of the probate court if the if PFAC isn't enforcing them in a way that's effective?
Thank you.
So that's my summary.
Go ahead and pull this up while she's introducing. Go for it. I'll pull this up while you're introducing.
Now I'm going to introduce my favorite professor. Even though I have graduated, she's still my favorite professor. Dr. Beth Ribet earned her doctorate from the University of California, Irvine in 2005 in social relations, sociology, and anthropology, and her JD from UCLA Law in 2009 with a concentration in critical race studies. She wrote her doctoral dissertation based on interviews with Jewish daughters of Holocaust survivors in the United States. In 2014, she co-founded Repair, a health and disability justice organization in the Los Angeles nonprofit sector. Through her work with Repair, a health and disability justice organization in Los Angeles, she focuses on training, publication, advocacy, expert testimony, and community education about the health and disabling effects of violence and inequity, and possibilities to make deeper systemic changes. In addition to her nonprofit sector work, Dr. Ribet is a lecturer in gender studies and disability studies at UCLA, and has taught previously at UCLA Law and Columbia University Law, among other institutions. Virtually all of her research and teaching incorporates some focus on the role of subordination, violence, inequity in creating new disabilities, injuries, and illnesses among vulnerable populations. She also speaks publicly as a survivor of violence and a person with disabilities. Welcome.
So thanks to Anam and to the panelists. I should have gone first. It's a little hard to follow Ann and Brooke. And I again want to express appreciation to the audience for canceling whatever could have been in your day-to-day. Time is really precious, and I'm definitely feeling how important it is that you're all in the room. I also want to say that the issue of guardianship and conservatorship abuse is very squarely in my organization, Repair's mission. We focus on the ways in which violence, exploitation, and inequity disable people, sicken people, or escalate conditions that are already there. And when I look at the dynamics of conservatorship and guardianship abuse, it's not just about assets, which is, a major issue in and of itself. It's about tremendous trauma. And one of the things that we know about traumatic stress is that it makes any condition you already have worse, and it creates new mental health conditions on its own. So, one of the reasons I'm glad that we're taking on this conversation and this work to the extent that we can is that conservatorship and guardianship abuse is injuring, is sickening, is disabling people, and I really see it with that frame. So I'm going to move to our first slide. Great. The word gentrification is in our event title today, and it was a little bit of a dilemma. We had conversations with those who are involved in planning this event about framing, and because conservatorship and guardianship abuse, first of all, involve a lot of syllables, second, involve a lot of states and district and territories, and involve a whole different set of legal systems depending on where you are, right? Even thinking about how to sort of frame the issue is tricky. And I said, I think I want to get gentrification into the title. It won't be the only thing we talk about, but we need to speak a little bit about it. We need to think a little bit about it. So I want to just introduce the concept. Some of you I know are very familiar, so bear with the 101. And, I want to start by saying there are a set of cities in the United States that are the most concentrated sites for gentrification. Los Angeles is one of them. San Diego is another, but also Chicago. DC is actually the fastest gentrifying area in the country. New York City, of course, Philadelphia, Baltimore as a DC suburb. Not that it's a suburb, actually, it's a city, but as it's DC adjacent. Gentrification, as many of you know, is the process in which a neighborhood or an area or region begins to displace its long-standing residents, and property values go up, and people who are lower income are pushed out of the neighborhood in various ways, right? And it's in many respects, distinct phenomenon and its own problem. It's not something that had to be having anything to do with conservatorship or guardianship abuse, except in a very big picture way. But the two have become, in certain spaces, intertwined, not always. Just to let you have a sense of the scope, since 2000, around 450,000, 464 was the last statistic I saw. 464,000 people have been essentially in one way or another displaced, pushed out of their neighborhoods by gentrification. So it's a lot of people. And we have a bunch of gentrifying areas in California: Sacramento, San Francisco, Oakland, Los Angeles, San Diego, San Jose, and Fresno. When I move to our next slide, there's a couple ways in which gentrification, conservatorships, and guardianships can overlap. I'm going to start with something that's ongoing right now and the framing around it. So just this year, on June 4th, the San Francisco Board of Supervisors voted 10-1 to implement a new ordinance, SB 1041, which expands conservatorships, right? So it allows them to be created more easily and for more things, and particularly targets people who are substance abusers or people with any kind of psychiatric condition. And there was one lone nay vote from a supervisor by the name of Shimon Nelson, and he spoke out, or Wilson, excuse me. Walton, thank you. Reading from my phone, because I feel like I'm craning my neck when I look up at the screen. And his objection was, I think expanding conservatorships is going to end up hurting people of color. That was his argument. And there were a different set of motivations, it seems, attached to SB 1041 than the ones that we've been hearing about today. One of the concerns raised is that establishing conservatorships of people who are poor, vulnerable, people of color in these neighborhoods makes it easy for someone else to sign away their rights and move them out of gentrifying neighborhoods. And so Shimon Walton was basically heralding, we think this is going to happen. But also, simultaneously, there have been a set of dynamics in the San Francisco Bay Area, and I want to really highlight West Oakland, in which for homeowners, right, the presence of gentrification makes people who normally would not have been such an attractive target and potential victims, potential prey for these professional predators. So if you look at West Oakland, this is a very historically poor Black area in Northern California. And it's been, really dealing with severe poverty over generations to the point where it's hard to find fresh food. If some of you've heard the term food deserts, areas where you can't get real grocery stores, there's just convenience stores, liquor stores, fast food everywhere. Like people have had to build gardens just to get decent groceries to the neighborhood. So these are poor people, and not who you would think of when you think about like wealthy people being targeted by professional conservators or guardians. But what we've started to see in the last several years is as West Oakland is gentrifying, as people are moving into West Oakland who are not African American, not from the neighborhood, who have more wealth, and starting to buy up homes because the areas in Berkeley and San Francisco, surrounding areas, are so overdeveloped and so expensive that anything anywhere near the area is now getting gentrified. And what we're seeing is that elderly African Americans in West Oakland are becoming targets for professional conservators. So these are people with almost nothing in the bank, or a little bit. Maybe they've got Social Security, maybe they've got a pension of some kind, right? But folks who are still living low income, some of them qualify for food stamps, right? But they have one very valuable asset, which is a home that they might have purchased, may not own completely, may still be paying a mortgage on, but in which they've built up equity and they purchased it for a tiny, tiny fraction of its present day value. It was something a poor person could save for and afford and get maybe 50 years ago, right? And so now these homes are starting to be worth up to $1 million, over $1 million, even though they're in these really poor neighborhoods. And so you're seeing professional conservators use these same patterns where they're going into courts and they are, doing so without the knowledge of the person or their family, and basically saying, "Oh, you've got to make an emergency decision, Your Honor. My neighbor is, who's never met this person, right? My neighbor is elderly and infirm, and she's unable to come, and I need to care for her, and will get awarded conservatorship of this complete stranger." And then you see very parallel dynamics that you saw to those in the film. People having strangers show up, tear them out of their homes, sometimes carry them out on their gurneys, and engage in rapid home sales to turn this around. And then those folks are going to wind up maybe eventually reclaimed by family if the conservator is willing to walk away once the assets have been drained, or winding up in a state-level nursing home. And I wanted to really get that issue on people's radar because I don't want the issue of conservatorship and guardianship abuse to be misunderstood as a problem that only afflicts the wealthy, right? This is a problem that afflicts anybody who has assets, and in fact, low-income people in gentrifying neighborhoods who have a home are really ideal targets, right? So conservators like to target people with some wealth, but we don't hear a lot of stories about conservators trying to go after billionaires, right? And there's a reason. If you have a certain level of wealth, you are going to be able to afford to defend yourself legally, to call in favors, to do whatever it takes to get yourself free of these people. So they're looking for folks ideally with some decent six-figure assets, but not the super wealthy. And so actually low-income people with a home, right, are perfect targets because they're going to have no sense of how to defend themselves from this kind of predator because they're not used to being able to have full access to the legal system. And this really gives me chills when I think about what I know about the present dynamics in real estate, in housing, in homelessness in Los Angeles right now. So one of the things that we see is that we've got at least 3, I would argue a few more, but at least 3 indisputably gentrifying areas in LA. One is Compton, another's Inglewood, then parts of East LA, some would say Wilmington as well, right? So we've got these areas that are increasingly ripe in terms of the potential property values and what they're projected to be in the next 10 years. And these are communities with high rates of homelessness. And one of the things that's significant is that when there's one elder family member who has a home, for extended family, that home may be a defense against homelessness, right? There may be multiple people living in that home, depending on that home for their survival, right? It's common for family, adult family, extended family to live together when folks have limited means. And so those homes are, often what's standing between expanding homelessness and gentrifying communities. So, next slide. What I want to just highlight here is that if we see, right now we're just seeing individual anecdotes and cases, right, of conservators targeting victims who are low income in gentrifying neighborhoods. And so I wanted to start to have this conversation loudly and quickly now to say that I'm really concerned that gentrification and conservatorship are going to kind of get into bed together and create absolute devastation for communities that are already very desperate and at risk. Escalating the displacement of families of color, right, is one of the things that will basically speed up the gentrification process, right? A conservator sells a family home, that family is struggling to figure out where to go, and that home is sold often to people outside the community. So I particularly want those in the audience who are concerned with gentrification, homelessness advocacy, racial justice, to start to think about where we may need to build across conversation. Next slide. And we want to understand something about the contemporary movement against conservatorship and guardianship abuse. Some social movements evolve over a lot of time because they're grounded in particular long-standing inequalities. And while there are deeper social strands of, sort of exploitation of the elderly, for instance, of people with disabilities, of wealth inequity, that are certainly part of the landscape of conservatorship abuse, this is not a problem that is centuries old. It's one that's now, I would say, a couple generations old. And so one of the things that we see is that the victims come together on no common basis except having this really terrible traumatic experience, right? The victims can be anybody vulnerable, and people didn't know each other before, and they can connect really intensely. And a lot of them were never people who thought about being activists or organizers or advocates before this. Some were, right? But most weren't, many weren't. And so this is a movement, the movement to confront guardianship and conservatorship abuse, that's kind of floating and a little bit disconnected from the other movements it should be connected to. When I talk about guardianship or conservatorship abuse, it's really hit or miss, even among people who are very, very invested in disability rights, for people to not have a sense of like, oh, what's the dynamic, or to have heard of some of the sort of more classic forms before professional fiduciaries came on the scene, where you'd have like an abusive family member taking advantage of somebody in a conservatorship or guardianship. But in terms of sort of recognizing the scope of this, even people doing disability rights work don't necessarily have a lot of education or knowledge or awareness of the issue. I don't know how many times when I brought this up to friends or colleagues, I've had folks say, I had no idea. And say it with surprise because they rightly consider themselves people who are politically educated. But that's what happens when a movement is disconnected from other social movements. So one of the things I want to say today is that I think there are a set of ways in which we need to get this conversation connected. I think we need to be building alliances with folks who are resisting gentrification. There are also, again, different reasons why people are critiquing conservatorships and guardianships. So we're very focused today on professional abuse, professional predators. And we need a lot of days to focus on that. It's an urgent problem. But guardianships and conservatorships have also just been critiqued for a long time by disability rights advocates, saying this is not a way, and Brooke was getting at this very beautifully, this is not a way to preserve the decision-making that people are capable of having. This is disempowering. This is a system that opens itself up to abuses. So I want to talk about the fact that we really need to be basically building alliances, building connections between movements if we'd like to see things change. Next, second to last slide. So I want to talk about what I think the future should look like. I frame this as what does it look like? Well, it's really what should. We need to be looking at supported decision-making as an alternative legal and social model for how to handle situations in which someone genuinely needs help making decisions, support in securing basic care for themselves that they're not able to provide for themselves directly. And supported decision-making is a model which basically, one, involves a lot of different support people and stakeholders. So the likelihood of one person being able to get away with so much abuse because they've been given so much authority, right, is much less. It doesn't mean supported decision-making can't go wrong, but it involves a lot of stakeholders. And its guiding principle is that the person who is receiving support should be supported in making their own decisions to the greatest extent possible. So under this model, instances where someone would be dragged out of their home in a gurney would be nearly unthinkable. And there would be a very high standard, right? It would have to be that this person was being proven to be a severe and immediate danger to themselves or others to involve that level of interference with the person or the body. More akin to the ways in which we look at things like civil commitment. Should conservatorships and guardianship systems end? This is a good question. I'm not going to provide a simple answer today. What I want to say is we need to be talking about, do we want to keep these systems in place at all, right? Is the goal reform, or is the goal to replace them, right? And I don't have time to unpack that further today. Until or unless we do decide as a nation that we're going to just completely abolish conservatorship and guardianships, and that would actually be pretty complicated unless it was a move at a federal level, because we've got so many stakes and municipalities with basically a finger in this pie. You know, when I think about why is this occurring in California, I keep coming back to the same thing, right? Predatory, exploitative people, essentially con artists, right? Find lots and lots of ways to work systems and abuse people. That's no surprise. What concerns me, and why I think the problem continues, at the heart it's in the probate courts, right? The heart of the problem, I think, is in the courts, because it should be, if our legal system were functioning in a way that was all equitable and at all safe, that the level of long-term ongoing abuses that we've seen just couldn't have continued in such a serial way without the complicity, the complacence, or in some instances, just the inattention of the courts, right? So I want to really highlight that, especially for those who are thinking about advocacy priorities. Reform in the probate courts, which is reforming courts, I want to say this as a legal scholar, is never an easy process. But we know that court reform does respond to public pressure, right? And we know that when we get multiple different stakeholder entities involved, that help. Since I'm running out of time, I'm going to move to my last slide to talk about things to do now. One, I really, really want to see increasing press coverage focused on the probate courts. It's good when we have a focus on corrupt conservators themselves. Some of you may have recalled, for instance, the fairly lengthy expose that the LA Times ran all the way back in 2005 about professional conservator Frume Lebeau, who continues to operate, who has conservatorship over family members of people in this room, whose office is located right down on Westwood Boulevard, right? She's, doing what she's doing today within 2 miles of us, right? So this expose, highlighted the fact that she, her fancy sports cars and the just millions of dollars that she was taking from her clients, and the fact that she would only accept ones who, were well into the 6 figures. And there, at this point, there are documented reports that she's been one of the folks who's been overbilling. So, when Frume Lebeau is filing and indicating that she's spent 30 of the last 24 hours, right, working for her clients, for most of us, that would say, you know, we would still have to check, is that true, right? I've heard that. I have not looked at the records directly, so I don't know. But as soon as you hear something like that, there should be multiple entities that are saying, oh, we need a fraud investigation. If this person is court appointed and there's something that obvious, let's look into it. So it should be, right, the elder abuse and fraud divisions of the sheriff's department, the elder abuse divisions of the LAPD, right, the elder abuse, the fraud divisions of the district attorney's office, just at the local level. And then, of course, we need the California Department of Justice to be looking into those kinds of reports. So one of the things we see is that the people who are doing this have been exposed. Our press did its job. Our families, our advocates, our victims did their very difficult jobs of speaking out. And we're still not successfully shutting these people down here in LA. So I really want to just say we've got to get we've got to get the press to cover the courts. And I want to particularly just highlight, and I'll close with this because there's not really, two things I need to say. I want to highlight, again, you know, this has been an ongoing process in Southern California and the state of California of exposing, investigating, shutting people down. And as we saw in the film, we still see that a lot of the system continues unchecked. So some of you may have heard of a professional conservator some years ago by the name of Bonnie Kumbalik. How many of you have heard that name? Well, she's incarcerated now. She got a more than 20-year sentence, as did her attorney, Michael Malloy, who was advising her on how to rob her conservatees. So Bonnie and Michael, somewhat like April Parks, right, were caught stealing millions of dollars from their clients. She used to run a company called West Coast Conservatorship. She was based here in Southern California in Riverside County. And this was around the beginning of this millennium, so this was over 15 years ago, right? And the judge, who was mostly working with and awarding clients in this case, was a state judge by the name of William Sullivan. So it was found that Judge William had actually been buying up at least one of the conservatees' homes, right? So he was awarding its conservatorship, and then he was buying below market so that he got to make a bunch of money directly himself, right? Buying up the home of the person he had conserved. And the documentation indicated that he may have made up to $1 million out of inappropriate financial dealings, where he was essentially in cahoots with Ms. Kumbalik and her attorney, Michael Malloy. So the good news is that after this was exposed, Judge Sullivan was unable to practice, right? So he's not allowed to serve in any California state court. But whereas the conservator and the attorney who were colluding in this conspiracy, essentially, are both now incarcerated. As far as I know, they've not been released. Judge Sullivan got community service, and he got a fine under $30,000, right? So one of the things that tells me is that the willingness to hold corrupt judges accountable is really, really weak. And we've got to work pretty hard on that. We've got to get the courts focused on that. Because one of the things that happens is when a family member calls up and says, you know, this is happening, I need you to investigate, and then they hear, well, it's a court-appointed conservator, and then the judge vouches for that person, they stop investigating, right? And so a lot of the entities that are supposed to be catching this aren't doing this in the way that they might if it were a private nursing home where the same allegations were happening. So the legitimacy of the court is insulating the practices, which means that I feel like the most vital thing that we need to do in California, besides listen to each other and build alliances and understand the issue in all of its racial, economic, and disability-based dimensions, so lots of priorities, but we really, really, really need to shine a tough spotlight on the probate courts and to make it so uncomfortable for judges who are colluding in this kind of abuse that they'll stop. SB 303.
So we'll start the Q&A with 2 questions. SB 303 was just signed into law by Governor Newsom. Would any of the panelists comment on how the new law may change the landscape for California conservatorship?
Yeah, we're trying to pull up the text of it, but so I first just need to acknowledge Senator Bob Wachowski, who is the sponsor of this bill, and acknowledge again Linda Kincaid and the folks at Cedar who collaborated with his office. Hooray for Linda. We should have really had you on this panel, but hopefully folks will get to interact with you more after. So this bill is a good step. I want to quickly explain, and I want to leave time in case either of the other panelists want to comment, but I want to quickly explain what it does. What SB 303 does is create a few more safeguards to make it less easy for a professional conservator to sell off someone's home. So it used to be that the legal standard to sell a person's home was that you just had to provide what's called a preponderance of the evidence, which is basically the lowest evidentiary standard, indicating that it would be in the conservatee's best interest. Preponderance of the evidence basically means it's enough if the evidence suggests that something is probably true, right? So for the court's purposes, that usually meant it would be enough for their court-appointed servitor to say it was true, right? So this changes it to you must have clear and convincing evidence, meaning there has to be more than a conservator, at least if the courts are applying the law properly, there has to be more than a conservator saying it's in the best interest of the conservatee before they can sell their home. They have to provide the courts with evidence about why they should not live at home, with the legal presumption being that home is actually the least restrictive environment until you can prove someone needs to be out. So this is vital if it's actually applied correctly and enforced, and one of the things that seems very promising to me, again, in terms of combating things like the intersection of conservatorship abuse and gentrification, because in those cases, the whole target is the home, right? So we still have to rely on the probate courts to follow the law. So SB 303, until it's actually applied and enforced, is a piece of paper, which means we've got to watch, right? What do the courts actually do with this? And we've got a few other challenges with that, and one is that at least in LA County, we know that when a family or a conservatee tries to get their own attorney, let's say from a private legal aid organization, or a public one like Disability Rights California, if that attorney shows up in court, they are automatically removed by the probate courts, and they replace them with their own court-appointed counsel from a panel that those judges have trained. And then they remove them immediately after that hearing is over, which means that there's no attorney in place to appeal. So you can understand why this creates like a huge conflict of interest in the probates courts, because your counsel's supposed to be the person who can do something if they think the judge screwed up. But with the courts controlling the attorneys on the case and removing them immediately after a hearing, essentially nobody has a functional right of appeal, which becomes a due process issue. So SB 303 won't actually solve that yet, but it does at least tell us that the state legislature is paying attention to the problem. And it does one other really helpful thing I want to mention, which is that it requires home appraisal before the sale. So a common practice among professional conservators who are corrupt in California is to establish relationships with realtors who are their buddies, and basically to sell homes at well below market rates, as they did to Judge Sullivan back in the day. And then they're basically profiting in various ways, some which on paper can be legal, like commissions, and others which are, frankly illegal, like just splitting the proceeds, right? But these below market home sales save a professional conservator the trouble of even having to document billing, because maybe, they sell off a home that's valued at $750,000 for $150,000. And that money remains in the conservatee's estate, and they can bill to that. But all of the rest of that equity was lost, and they can take it really quickly. So home appraisals are a great step, and again, I'm really excited that California put this legislation into effect. Governor Newsom signed it. It'll be 2 weeks ago tomorrow, right? Brand new step. So implementation is coming, and this is really promising. Did you have any comments on SB 303? Okay. Okay. Oh, and I'll add one other note, which just highlights the point about the judiciary. One of the few opponents to SB 303 was the California Judicial Council. They showed up to protest it to the California Assembly, saying the heightened evidentiary standard would create too much work for them, right? So again, we really, and thankfully the California Assembly didn't listen to them, neither did Governor Newsom. They also contacted his office directly, right? So we need to really understand that we have to put a lot of scrutiny on our state courts because some things are really going wrong.
Sorry, I just wanted to add, this is where the family advocates would come in play, because we had sent out an email list to make sure that we all write in to the governor's office to make sure that he does not grant that opposition from the Judicial Council. So this is where us as advocates and just basic, members of the public can really have that strength and authority just to write in to allow them to let them know that we will not take that.
Good.
Thank you. I have one more question, very important. What would you say to families and survivors who are losing hope about any prospect of stopping the abuse or exploitation that currently pervades existing in these guardianship systems?
I mean, I think with all social justice and rights-related issues, we see slow change, right? We rarely see the change at the pace which is acceptable. And so just that continuing to educate people to be involved. For part of how I started looking into this more, Linda doesn't know this, part of how I started looking into this more was that 4 or 5 years ago, I was giving a training to people who were going to watch law enforcement during protests to protect the First Amendment rights. And her friends showed up to learn how to watch things and to see if there were tools we were giving that they could apply to their court watch. And so while, certainly that day I was there teaching people how to protect protesters, it definitely just kind of the act of being out there and telling people there was a problem and showing up when I was giving a totally unrelated training was one of the things that got me interested in what was happening in this particular area of law. So just continuing to, like in all kind of justice movements, right? Educate people, speak up when you can, work with your politicians, even at your local level, when you have your local elections for district attorney, ask them what they're going to do on this issue, and getting as many people as you can to recognize that there is a problem and that there needs to be some better solution than what we have right now.
I really have to ask a question. I'm sorry.
We will do audience Q&A, but not yet. Go ahead, Ann.
So as a family member and the family perspective, I would say just don't lose hope and keep reaching out, because it's a hard road and it's very challenging. And there was times that I would shut down and I didn't want to speak to anyone because I didn't think anyone was listening. And then when I was able to emerge out of that and move beyond the pain, beyond the disbelief, then I kept reaching out. And that got me to where I'm here today. And just don't lose hope. I know it's always, as Dr. Ribet had said, it's a long process. And it's just like a battle that you just keep going. So it's not a sprint, it's a marathon. So just make sure there's balance of self-care and just keep coming and don't give up.
Thank you.
I already went over time, so I'll keep it quick, but I echo Ann's point about self-care and just recognizing that the survivors of the abuse, and I include affected family members, not just conservatees and wards, have been enormously traumatized. And we need to respect that, hold that, create spaces where we can address that. And I'll also say that I think fundamentally the issue will achieve the level of attention it needs to receive the more we connect it to other social justice struggles. There are a lot of good people who care about human rights, health in the United States. Lots of good people, but the challenge is there's so much wrong. so many issues to work on, even just within the arena of disability rights. And so we're all spread too thin. So we need to be figuring out, how do we collaborate, how do we merge our efforts in ways that simultaneously address two issues which actually are intertwined, because it creates efficiency among people whose energies are really precious, really valuable, and really scarce. So what I would say to folks who are doing this work is create alliances, figure out how to connect this work to other forms of work. Be ready to learn, to challenge your own assumptions in order to become somebody who can do that. And I'm still talking a lot, so I'm going to stop. So audience questions?
And did you have a question?
Can we do the mics so that we can get it on video?
I'm not sure I want to be on video. Thank you for taking my question so quickly. Are there consequences for violators of this law? The three? And how would those consequences be instituted, and who would do the litigation, et cetera, et cetera?
Assuming no one else wants to field that one. In essence, again, on paper, there are consequences. I am not counting on those consequences being delivered without more monitoring and pressure. But yes, violating these rules in the courts can mean that your decisions are overturned, right? Ignoring the law for judges can mean charges of judicial misconduct if conservators circumvent this law and don't follow it and sell a home anyway without the court, without going through this process with the court. There can be consequences for them as well.
So my name is Lisa McCarley. You haven't heard of me unless you happen to be a family in Los Angeles, Orange County, or Riverside County who has been affected by this abusive system. It is a systemic problem, and I will ask you all to take down this address. This is the Chief Justice of the state of California. It is her job to make sure that our probate courts are functioning properly. They are not. Linda Kincaid, Richard Calhoun, Tom Coleman, and myself took ourselves to Sacramento to speak before this agency, the Judicial Council of California. We explained to them about the abuse and trauma that is being experienced. They never called back. They don't write, they don't text, they don't email. On the other hand, I have written to Governor Newsom. He has gotten back in touch with me. I have met with my state senator, Anthony Portantino. If you ask your state senator to meet with you, they must and they will. And if you need me to be there, I will.
I'm sorry, we don't have time
I
for
know,
longer
but
comments
just
right
one
now.
more comment.
No, I'm sorry. Do you have a question? If not, we'll have breakout groups.
The question is, if you're willing to make a change, please go to the
Okay, we're still looking for a question.
All right, so then the question is, there is a great deal of us out there wanting to create change. Is there any one agency where we can all affiliate together? Because we have all these different people. We have CLEARS, we have CEDAR, we have my organization, we have Tom Coleman's. Are you aware of anyone? And the other question is, why aren't law schools getting involved in creating programs to educate people how to deal with disability rights? Because that's really missing too.
Okay, thanks. Tackle either of those?
I actually took a class, disability rights law. And
So on the question, I'll try to tackle the question about law schools. There are schools that I think are investing in disability law. As much as I'm a UCLA Law alum, I'm sorry to say UCLA has not historically been one of them. I'm not a football fan at all, so I don't mind mascot rivalry, but our supposed rivals across town at USC are actually much more engaged with this issue. So I'm an enormous supporter and fan of the Sachs Institute for Mental Health Law, Policy, and Ethics. And one thing that I think will make a lot of people in this audience really happy, have folks heard of the millionaire's tax? Okay. It was on the ballot some years ago, and it created a fund where the wealthiest people in California were taxed to create a pool of money to support mental health. So, sounds like a good thing. And they have just, that pool of money out of that fund has just given the Sachs Institute and USC about $500,000 to start the process of basically researching the viability of replacing systems in some instances, like guardianship and conservatorship, with supported decision-making models in California counties. They're just beginning the process, and based on what they find, the state of California has indicated they will fund them more heavily to actually then start help counties implementing it where possible. So one of the things I would say is that, I give USC full credit. There's a law school that has, thanks to the presence of Ellen Sachs, is doing incredible work on this. With that said, it's a good critique that disability law is an undervalued, and elder law are undervalued specialties. And that's incredibly foolish of those law schools that neglect these areas, because the baby boomers are retiring. Right? These are growth areas for their graduating law students who need jobs. I see we've got another question.
I just wanted to add on to that. I read somewhere that when children's rights began to become an issue, it started with doctors who began to see a lot of children with broken bones in hospitals. And so UC Irvine apparently has a Center for Excellence in Elder Care and Abuse.
USC stole it from
important.
us.
Can you say that again?
USC stole the Center for Excellence from UCI. It's here now.
Who stole it? What?
USC.
University of Southern California
Yes.
took
They
it over.
stole it from UCI?
Yes.
So it's over there right now?
Yes.
Okay. Well, it's closer to us. The second question I have about that is the Olympics are coming to LA soon, and I am my daughters work in hepatitis C and HIV down there, and so there's a lot of change happening. USC is getting into, on the streets with that. What is UCLA doing, and UC Irvine with that? And then two more questions, so if I may. Billy Mintz happened to mention the two-party rule on recording, and then I spoke with Karen, I believe, about some recording issues there for her, where even in her own home she's not allowed to record. I won't say very much, but and then I'm part of a group called Probate Warriors, just a little Yahoo group, and I'm noticing a lot of people are complaining no recording allowed in probate courts. So I would like to ask about civil disobedience when we are concerned about we suspect violence or extortion, which according to Bill Lockyer, AG 99-403 is allowed. What is your opinion on that? And then finally, my other question is, third last question, if there was a lot of work and elder abuse and all of this is 30 years behind, I've heard it said, children advocacy, why can it be that we can go into that law and ask the Attorney General or legislature to look at these laws and apply them to elders on the other spectrum of age?
So I didn't have a pen to take notes during the question list, but a couple of quick thoughts in terms of kind of like senior services, disability rights in general, right? That despite the fact that we will hopefully all make it there, it is not a thing that people, particularly funding sources, seem to be excited about yet, and hopefully we'll get there. But I know when we are talking to potential foundations about grants as a young nonprofit, and we say, hey, look, we do this work with homeless folks, and we do this work with seniors, and I have a dream of having end-of-life plans for every low-income person and us being able to provide them, they are not excited about that. They are excited about supporting our special education work and our homeless services and citation defense. And so figuring out, what it will take, and there are some groups like Ageless Alliance, which came out of the Center for Excellence, that are trying to get more press around the stories of seniors and people with disabilities and trying to get more excitement around supporting that work. But we're just not there yet. There's not, and I think we also have this complicated issue of, and part of why the legal areas, particularly of senior services and disability rights, are starting to come together, is that senior is a really vague term now, right? Like there was senior at a time was sometimes 65 plus or 62 plus or 60. Senior communities are sometimes 55 plus. And people now live close to 100, often past 100. And so the needs of the 85 plus community are different than the needs of the 65 to 85-year-old community. And so as people are kind of scrambling to catch up in the medical community and in the legal community and kind of socially on what the needs are of our aging population, we also have medicine way ahead of the kind of regulations and support for those groups. And so they're not coming together yet, and hopefully they will. But we're in a place where there's so many different needs of so many different populations. It's part of why we see all of these kind of like seniors losing their housing and senior mobile home parks being bought and shut down, is that people just are not in a place yet where they're recognizing the variety of different ranges of seniors and needs of those ranges.
So as a family perspective, and also as a public service part of my life, as part of my profession, I would encourage, this is for Lisa McCarley's earlier question, is that even though there's not one organization or umbrella in the state of California, I would encourage you to ask your legislators and the Judicial Council to create what's called a public advisory committee that includes families and persons who will be affected, so that way they could have an independent arm to advise and to kind of do a checks and balance. So that way you get a diverse voice and something that could be appointed by the governor, especially if you have the eyes and ears of the governor saying, hey, let's see if we can make a checks and balances, including the voices of those who will be affected, instead of just relying on the judges and the appointed attorneys and the professional groups. So you have to bring in that community voice, and you can ask for that. Create those committees and make sure that we're well represented on those committees.
Mm-hmm. We're running over time, but I want Roger to be able to pose his question, so I can speak to things like civil disobedience after, maybe. What about the recording issue?
Oh, yeah, there were so many questions. The two-party recording, I forgot it.
Gotcha. Does anyone want to field that real quickly?
I mean, it's not something I've specifically looked into. Generally, in any court proceeding, you can bring, at a minimum, a court reporter. And so there's a record of what's said, even if it's not necessarily like video recording. But it's in all of the courts, the courts are behind technology and what's allowed. And so you do have to get special permission to do video recording. Mm-hmm. They won't let you bring your court reporter.
Another area to work on, but again, we've only got time for this last question, so we can talk after.
Yeah.
Right. Yeah. So like a hired court reporter is who, like, you can hire a court report, which is another expense, but that is the way in which you can get a recording.
Mm-hmm. Yeah.
Thank you. I think we ought to give Repair and Dr. Beth, a round of applause for putting this together. Thank you. Being that we're at UCLA Law School, my question for you, the panel, is I haven't heard it talked about much today, but there is a violation of due process rights for people in guardianships, because I keep hearing people say, well, the judge did this and the judge did that. Judges are to apply the law. Judges are to weigh evidence. In a lot of these cases, there isn't much of either. So my question for the panel is, because our Constitution, our state constitutions talk about our rights and our civil rights being inviolate, and your right to a jury, if juries were used more in these civil courts and these probate courts where they had to bring in more evidence, and a jury now is to make the decision versus a judge who's making one without evidence, would that help the situation?
Would it help to have jury rather than judges at the helm? Potentially, yeah. I think it could be a good thing. I can see ways it could go wrong too. I think it's a tricky question. But on the other hand, it's already going terribly wrong, so I can appreciate just wanting to try other avenues. On the question of due process, I think, Roger, that that's an incredibly important focus. I think we need to be talking about the embedded constitutional issues. It's been a while since I did it, but one of the classes I used to teach focused on women in U.S. history. And when I teach, I do still teach gender law and policy, and when I do, I'll include a historical component. So one of the things I'm talking through with my students is understanding historically what it meant to be chattel, what it meant to be an adult person who was essentially under someone else's stewardship, to not be allowed to control or own your own property, to not have liberty about where you could go independently, and what it meant historically when that was true for people on the basis of sex, right? And so, I think we also, and our constitutional law has evolved partly in recognition of that, in the ways in which supposedly benign systems that are supposed to take care of people who are vulnerable and who are less competent and who are, that we've seen how egregiously and severely that's abused, that spousal abuse, child abuse, that, the landscape for people who were female in a context in which your personhood was attached to someone else's guardianship, essentially, was always perilous, right? And could be hideously contorted in ways that absolutely destroyed lives. So starting to highlight for folks, what we're seeing is, in some ways, an extension of that legacy, right? That we need to vest the rights of personhood as solidly and as firmly as possible in the person, and that's part of what we talk about when we talk about civil liberties. So I think addressing this as a constitutional issue is vital. And of course, I have to acknowledge the obvious. The landscape in the United States for civil liberties is pretty bleak across the board, right? Not in any way that's remotely confined to conservatorship and guardianship. And so, for those who care about this issue, it should be something that pushes you to think about multi-issue reform and systemic support for every aspect of human rights, because that's the only way we'll really see our overall landscape change in ways that would protect elders and people with disabilities. Yeah, I think if Anam has any last comments for us, that's great. And we have a limited amount of remaining time for everybody to get to connect. Is there anything you wanted to wrap up with?